Okay, so YouTube is opening up, so we will go ahead and get started. I do have a brief presentation that I prepared for today, so I'm going to get that pulled up and we can get started. Okay, so um, YouTube is okay. So this month we are going to revisit intellectual property, and whenever we have a lunch and law topic on intellectual property, it tends to be very well received and very much needed. So I want to hit intellectual property as much as I can this year. The one thing about intellectual property is we all have it. Whether we realize it or not, we all have it because God has given us all brains. And God has made us all to be creative. I know we all have different degrees of creativity, but I believe because we are created in his image that we are all creative to an extent because God is creative. And he also gave us the ability to name things, right? He told Adam and Eve to go, not Adam and Eve, he told Adam to go name the animals, right? And so he empowered Adam to be a creative and gave him that mandate. And so I believe that that was passed on to us. And so we should walk in the fullness of that. Part of walking in the fullness of who we are as creatives is to protect our intellectual property. And so that's one reason why it's so important to me that we really get these IP topics down and that we discuss them thoroughly. So today we're going to be discussing licensing agreements, and then we're going to talk about responsible AI just a little bit at the end. It's like a little bonus. Okay, so for all of those who are new to our membership or new to me, Chenault Legal and Consulting Group is a business and civil rights. Every time I come on here, I say I need to respell civil rights. But it's a business and civil rights law firm in Atlanta, Georgia. On the business side, we assist Black and Brown entrepreneurs with building legally sustainable empires by empowering them with effective legal strategies in the Word of God. And so that's what we do here in the Lunch and Learns. And just in general, any type of class that you have with me is typically going to be infused with the Word of God and effective legal strategies. Believe it or not, our law is based on the Bible. We got a lot of our foundational principles from the Bible. And so we use the Word of God because, I'm a believer and I believe a lot of my clients are also believers, but it also helps us to understand some of the tenets of our law. Okay, so let's hop in. What is a licensing agreement? So if we had live attendees here today, I would have opened up the floor for you all to let me know what you think a licensing agreement is. But since we're not live today, I will just go ahead and answer it. So a licensing agreement is a contract, right? You guys know how I love to harp on contracts. So a licensing agreement is a contract between two parties in which the licensor grants the licensee the right to use a piece of its property. And so think about it like this, if I say, so for instance, Victoria is one of our members. She owns a brand. If I say, hey, Victoria, I want to create I want to do my own music video, but I want to be able to put your name on it. She would have to grant me a license. I would be the licensee and she would be the licensor. Or she could come to me and say, hey, Kiana, I'm going to law school. I want to open up a Chanel legal and consulting group in California. Well, in that scenario, I would be the licensor and she would be the licensee. So basically, the person who's given the permission is a licensor. The person who's receiving the permission is the licensee. Licensing agreements can cover both intellectual property and physical property. So our intellectual property, I would say that might be more popular than the physical property, but we'll discuss both. Intellectual property includes brand names, trademarks, patents, copyrights, any type of technology that may not be covered by patent. Everything is not patentable, but there may be another type of technology that somebody comes up with. I'm trying to think, software that can kind of be a good too. So, but those are your intellectual property uses. And then you have your physical property, your goods and services, which the licensor owns. So, like the M in McDonald's, they may actually, I know the shape of the M is a copyright, but they may actually own that M. They may own the building, right? McDonald's a corporation, I mean, but they may give a franchisee who is a licensor, they might give them, a licensee, they may give them permission to use that building or to use that physical M for their store. There's also like Mary Kay, right? Mary Kay gives people a license to sell their products. So the products are owned by Mary Kay, but each individual, Mary Kay person, I know they're called something. I used to sell Mary Kay. I don't remember what I called myself. Consultant. I think it's a consultant. Each consultant has a license to sell those Mary Kay products. Think about also like a store that sells hair products. Well, those hair products have to give the store a license to sell their products. So that's an example of physical property. For the ladies that I know are members, I don't believe anybody would be given a license for a physical piece of property. Not anybody that I know of, but you may want to consider being a licensee of physical property. So that's why I want to make sure we cover both. But hopefully that's not confusing. So, and a lot of agreements may cover intellectual property and physical property. For example, the McDonald's, right? The M is not a copyright. The M is a trademark. So the M, the way it's designed, that's a trademark. So McDonald's Corporation would give the franchisee the right to use that M, but they might also give them the right to use that building, right? And so that's intellectual property and that's physical property. So some agreements will include both, but other agreements will be either or. If it's a franchise agreement, I would say 9 times out of 10, it's going to have both. Because if you're buying into a franchise or you're interested in a franchise, the fact that it's a franchise means that it's very well known, has a good reputation, right? And you kind of want to buy into that. So you already know you want to use a trademark. And then the physical things that come with that brand, they might have, certain fries that they sell, certain burgers that they sell. The goods that actually come with that brand, that's going to be included. So a franchise agreement is typically going to have both. But other agreements, like if I'm just using somebody's curriculum and I want to teach somebody else a curriculum that somebody else owns, that's going to be intellectual property only. Okay. Purpose. So as a licensor, so if you are the person who are saying, okay, you can use my idea or you can use my product, if you are that person, licensing allows you to replicate yourself with little input of your time. So little input is probably not the best way to put it because it can be very time consuming on the front end. So if you're a licensor, for instance, J. Nicole, I know she does coaching. She may have a strategic coaching strategy or strategic coaching curriculum that she wants to give another coach the license to use. Like, hey, you can use this specific strategy. This is what I call it. She will probably have to teach it to that person. She would have to, first of all, generate the agreement, right? Have the agreement in place, but there would be a training period. And why you would want that as a licensor is because you want your brand to be consistent. You don't want one person or one customer, one client to have an experience with J. Nicole when she's teaching it. And then when she goes to this other coach, the coach doesn't teach it the same way, or the coach is cutting corners. And so J. Nicole would want to spend the time training that licensee on the proper way to use her brand, on the proper way to use that curriculum. So it's little input on the back end, so once the new coach is up and running and they understand the curriculum and they're able to run with it, then J. Nicole doesn't have to do as much. But on the upfront, it is time consuming outside of putting the agreement together, actually training the person and making sure you feel comfortable with putting your brand in their hands, because how they treat your brand becomes a part of your reputation as a brand. So we have to be careful with that, right? And we'll talk about that. But aside from that time that you put on the front end, on the back end, it's very little time. J. Nicole would just sit back and collect her royalties. Royalties are what a licensor charges the licensee to use their brand. And so a royalty could be something from pennies on a dollar. Like for songs, I think they get pennies on a dollar for royalties. For sitcoms, I don't think they get pennies on the dollars, but I think they get a few dollars per like rerun sitcoms like Martin that, Martin plays on certain channels. The cast members get royalties from that. All the way up to movies that are on Netflix. Netflix has to pay the movie owners a royalty for that. And so if Netflix is the only platform that is on, then presumably that royalty is a lot. That royalty check is a lot. But that also makes sense why Netflix started making their own movies, right? Netflix got their own movies, they got their own shows. So that's cutting down on the royalties they have to pay. And I'm sure they probably have to pay less royalties in general because Netflix is a powerhouse in its own right. And so for a movie to be put on Netflix, that is a benefit for them, for the movie owner and the actors and the actresses. And so they probably have to pay less for that as well because it's a benefit to the licensee. I'm sorry, it's a benefit to the licensor, and Netflix will be the licensee. So royalties, money. That's what we're trying to get to. We're trying to get to the yams, right? And what I love about licensing is that once we get past that initial time investment and we're on the back end and we're just collecting our money, we can have the soft life that we want, right? We can have this team soft life and we can have the soft life and we would just literally be collecting our checks. So in addition to the soft life though, just being able to pass that down as well. So if we're, so I recommend having a shorter licensing agreement up front. Maybe 2 years max is probably the longest I would go. And then at the end of 2 years, you guys like each other. Yeah, we vibing. Let's make it 5 years. Okay, 5 years, we still good. Let's make it 10 years. God forbid, if something happens to the licensor, that contract with the licensee is still in place, depending on the terms of the agreement, right? But that agreement can continue to generate money for the heirs of the licensor. And we've seen that, Prince's estate and Michael Jackson estate, they continue to get royalties from the work that they did when they were living. So their heirs continue to get royalties. I don't know how much royalties they get because I've read a lot and heard a lot about the music industry, just cheating artists. We know that. Sorry, TLC. So I don't know how much they're getting, but their heirs continue to generate royalties. And we have access to that. It may seem far-fetched. But we have access to that. We can leave that legacy for our children and our heirs, and that's what we choose to do. And the licensing agreement is a way to do that. As the licensee, so if you are the person who's actually wanting to use a brand name or wanting to use a product that's already been established, well, you would not have to put the time and the energy into building up a business, right? You ladies are all business owners. I'm a business owner. So we know how long it took to get our name out there. You know, we know in the beginning it might have been kind of slow, maybe not for everybody, but for me, it was kind of slow like that first 4 to 6 months. You know what I mean? So it takes time opening a new business to get to a point where sometimes to get to a point where you're profitable, to be honest, but to get to the point where you can, you know, just work in your business and not have to work somewhere else and just really be sustainable. Sometimes it takes some time to get there. Whereas if you are a licensee and you decide, hey, I just want to open, there's no McDonald's, you know, in a 5-mile radius of my house. I'm going to open a McDonald's on this corner right across from QT. People can, you know, stop and get their coffee or stop and get their gas and then come right across the street and get their breakfast. I think this is a good location. Well, you wouldn't have to put the time and the energy into building up that brand, right? Everybody knows what a McDonald's is. Everybody knows what McDonald's sells. You wouldn't even have to think of a menu. You would have a pre-done menu for you. So everything will be cookie cutter and done for you as a licensee. And so the time and the energy that you would put in to your own business to try to get it to a certain point, you wouldn't have to worry about that as a licensee. But what you would need is money. You need money up front. And so the licensor, right, he or she is going to want their royalties, probably sooner than later. Sometimes there is a fee that you have to pay right at the beginning before you even start making any money. You have to pay a fee right there in the beginning. If you're buying products and things like that, those things cost money right now. And so when we think about being a licensee, in particular opening a franchise, the time it takes to build up the brand or to build up the name, that's cut down, that's gone. But whereas in your own business, you can bootstrap and kind of say, hey, I'm gonna get, you know, I got this invoice for $300. I'm gonna go, you know, hire a coach. That's gonna be, you know, $50, and I'm gonna keep $250, which is unheard of. But you can kind of bootstrap in your own business and kind of work your way up to larger expenses. It's not like that when you're opening a franchise as a licensee or any type of licensee. Typically, it's not like that because there's money that's due up front. Even if you're doing, if you're licensing intellectual property, you know, a trademark, somebody is likely not going to say, oh yeah, you can pay me for my trademark in a year. They want to be paid up front, usually something. And then they want to get a portion of your proceeds every month. So a licensor typically wants to be paid up front, and then they want to get some royalties every month. So you have to usually have more money coming to the table as a licensee than you would building up your own business. But like I said, proof of concept has been done. So, you know, you don't have to really worry about as a licensee, is this brand going to work? Is people going to want it? Because the interest is already there. That's why the licensor is even able to license their product or their service or their intellectual property. I got a good example for this. The Stanley Cup. So first of all, I didn't even know I think I had heard of Stanley Cup maybe like 20 years ago. I'm sure I've seen it in a TJ Maxx or something. But my bonus daughter, I was asking her, you know, what is your boyfriend getting you for Christmas? And she was like, oh, I sent him a list. And so I asked her, you know, what was on the list? And she's like, oh, makeup, this and that, and a Stanley. I'm like, a Stanley? She's like, yeah, it's like a cup. It's a cup. I said, oh, and I just thought it was so bizarre that she was asking for a cup for Christmas from her boyfriend. And I was just like, wow, I just thought maybe she just wanted to drink a lot of water. I had no idea. And then I know my husband's about to walk in. And then fast forward to oh, I'm on live. Fast forward to now, this is January, and I see the craze. I've seen the news, and I'm like, wow. But that's a great example of licensing, right? So Stanley capitalized on their popularity by saying, hey, Target, hey, Starbucks. Of course, I don't know how much they paid, but I'm sure they said, hey, Starbucks, Target, if you pay me some money, I will allow you to put my cups in your store. And so they were able to capitalize off of this craze and get them into some lucrative licensing agreements. And I'm just assuming that that's what happened, because that's what I would do. So that's a good example of, and then, on Target, on their back end, instead of trying to think of a new cup or try to compete with Stanley, hey, we can just enter into this agreement. The desire, the need, the demand is already there. We just need to have an avenue open where we just need somewhere to set it up. So, that's a win-win situation. So that's what you would want to see. Of course, we may not have that much interest, right? But if you are a licensee, you want to engage with a brand that already has that interest and demand already built in. Otherwise, just build up your own business, is what I would say. Okay, so impact. Licensing agreements allow parties to control property and enter new markets without having to spend money. So again, this is really from the licensor perspective. I'll let him finish. Okay. So if you are a licensor, for instance, Sharon has a balloon setup business, party decor, balloon setup. She does it all. She may not want to move to California. I know she has family in California, but she may not want to move to California to open up a Get It Poppin'. But what she could do is find another balloon designer in California and say, hey, I like your work. I think you would serve the Get It Poppin' name very well. Do you want to enter into a licensing agreement? And at that point, that person can open up a Get It Poppin' in California without Sharon. I'm sorry, I got a text. Without Sharon having to step her foot in California, unless she wanted to. Now, I would say, as a wise business owner, I know Sharon would go to California because she would want to see the space. She would want to see, where you're going to be setting up, let me see what your inventory looks like. Let me see these balloons in person. Are they, durable, sturdy? Or she may want to, say, hey, you can only work with these vendors for balloons. But so I'm sure she will go in person. But my point is, she wouldn't have to. She could expand her brand to California. She can expand it to Ghana. She can expand it to Italy if she wanted. I'm going to say that's not advisable because they don't have to stick to our contracts, but you get my point. You can expand to markets as far as you would like without having to step foot there. So, and without having to spend the money, that's the thing. Without having to spend the money as the licensor, all that's going to be the licensee would have to pay. Another thing you want to consider about impact. So that's a good thing, right? And then as a licensee, also being able to bring a new service or product to an area, that's also exciting. So that's exciting on both ends as a licensee or a licensor. On the negative side, right, the impact. So a company's reputation can be on the line if they allow the wrong company to license their brand and vice versa. So in that example, if Sharon says, hey, you're good. I vetted you. You're going to do great. This is how we do Get It Poppin' setups. I know Sharon has a special software that she uses. Hey, this is the software. These are the brands. This is what our client journey looks like. And she teaches her, she trains the new person, and she says, have at it. And then the person opens up in California and it's going well until the person in California lines up, 10 parties and doesn't go to any of them. And then those customers might be calling Sharon saying, hey, I know you to Get It Poppin' in Atlanta, but you own this brand and I spent $5,000. This is 10 people that have spent $5,000 on their party, and the Get It Poppin' California owner did not show up. And so now Sharon, God forbid, is possibly looking at this $50,000 problem, right? That's a mess. And then as a licensee, right? If we do own a McDonald's and then, you find out in the news that the food don't go bad, the food don't grow mold after a year, the cheese haven't melted, anything. Well, that might impact, your whether or not you're getting customers. And so it goes both ways. So that's why I said definitely as a licensee and or licensor, you want to do your research on both sides. You want to buy, if you're going to be a licensee, you want to buy into a brand that you believe in, that's aligned with your principles. You want to ask those questions. If that's a concern to you, what are these fries made out of? What are we frying our nuggets in? Are the nuggets real meat? These are conversations you want to have. And then as a licensor, you want to Google, you want to read reviews about that person's other business. Did you see reviews where it said, she didn't show up to the party? Did you check the Better Business Bureau in California to see if there were any complaints? Did you run that business history in the county where it lives to see if there's any pending lawsuits? So both sides definitely need to do their due diligence and or hire somebody that's going to do the due diligence for you so that you're making an informed decision, because the impact can be great on both sides. It could be a great impact, right? Or it can be a great impact in a bad way. So we want to both be careful on both sides. Okay. So the agreement itself, I'm not going to go too much into the weeds, right? Because that's why you have an attorney, right? So the attorney will get into the weeds for you. But these are just some things that you want to keep in mind. It will have the parameters for usage. So if, for instance, Victoria, if she wanted to let me use her Hello VNO brand for my music video, I know she has some parameters for that. I know she had let somebody else use it, and I think they may have flashed it too soon. She may want it to play for 10 seconds. She may want it on in the beginning and then at the end, in the opening credits and at the closing credits, So there are going to be parameters for usage. There's going to be an applicable timeline. Again, I wouldn't go longer than 2 years for the first agreement because we're kind of, filling each other out. So it's going to have the timeline for usage. It's going to have the scaling terms. So if, for instance, if J. Nicole says, hey, you can, I'm giving you this curriculum to use for your students, pay me $50 per month in royalties. And then that person has, let's say she said, pay me $10 a month in royalties, and the person had 2 students. Well, then the person gets 100 students, right? Because the curriculum is so good, the coaching method is so good, she may want her royalties to go up. Well, give me, $15 per month, for each person, give me $15 for each person that you enroll. And so you can expect on both sides, if you're the licensor, you should have some type of scaling provisions. And as a licensee, you should expect that as well. And then on the reverse side, right? Well, that's kind of why the agreement will be short. But if you're not making money, it's not in the licensor's best interest to see a faction of its brand go down the drain, So maybe there's a caveat for a decrease, royalty, or a caveat where the contract is for a year, but maybe we can break it a little early in these circumstances, right? So scaling terms might be some descaling terms as well. And then parameters on the item being licensed. So in the example with J. Nicole, am I able to call myself, J. Nicole Mableton? And can I use that name? Can I just use the curriculum? Can I use a J. Nicole trademark? You know what I mean? And so the item that's being licensed is also going to be included. So be specific, as a licensor and licensee, what is it that you actually want to license? I don't think I would want to license the McDonald's name without having the McDonald's food, right? Because people are going to come expecting a certain thing. And if I can't deliver, that's going to be a problem. And so some things are married together in terms of what items need to be licensed together. So just make sure that those items that need to be married together are married together. Okay. Are you interested? I believe that many of us have access to a brand, whether it's our own brand or a brand that we're interested in. We have access to a brand that we may be interested in as a licensee or a licensor. I know I'm in Mableton, and there was a Krystals that shut down close to us. My husband was like, I wonder what we could put there. And I'm like, that's a good idea. I actually looked into a franchise. I don't even remember the name right now, but I was like, I would love to open something and not have the pressure of coming up with all the ideas and the products and the payment systems and things like that. And I'm sure some of you may have thought the same thing. I have a client who recently opened a laundromat, and I'm told that a laundromat / cleaners is like the fastest growing franchise to open. And so, well, it could be a franchise or it could be a standalone, but they're doing really well. But anyway, it's an everyday married couple, not a Warren Buffett that's just super rich, but an everyday working couple that said, hey, we want to open another stream of income. What should we license? And they decided to go with the laundromat. As a brand, as a licensor, Victoria, I know she has already licensed her brand because she's already built up her reputation in the in her community, where she's doing directing and she's working on videos and she's getting those angles. She's already built up a name for herself to the point where artists want to have her brand name on their video. And so we have access to that as well by doing great work. I believe Sharon for Get It Poppin' has considered licensing her name to other people because the Get It Poppin' brand is so big. I know on the flip side, she's considered, receiving someone else's brand. And so these things, it can be accessible. I believe it's accessible to everybody who wants it to be accessible to them. And so if you're interested in licensing, think about that. What product or service am I interested in, or do I want to give access to if you're going to be the licensor? If you're truly interested in licensing your own things, the best thing you can do is do an amazing job. Like Victoria does an amazing job. Sharon does an amazing job. You ladies all do an amazing job. But they have carved out a niche for them in terms of their brand. And so it's some people I know doing an amazing job. I'm not picking on coaches, but there are a lot of coaches who will coach like under their own name. And so they're not necessarily building up a brand. The same thing with me, right? Chenault Legal Consulting Group. That's my name. That's not a brand, but that's what I'm working on. That's what I've been working on in the last year, is coming up with a brand that's going to be part of Chenault Legal Consulting Group. Is something that I can license, something that is separate from a name, because many people is not just going to want to be called Chanel. You know what I mean? Unless that's really your name. And so I challenge, the coaches, the attorneys, the accountants to, if you're interested in licensing, develop a brand and I won't say get away from using your name, but have an add-on is what I'll say. And so that's something I'm working on. But the best way to make yourself marketable is in terms of a licensee wanting to pay you for your intellectual property is to do a great job and to build up a great brand. Research on both sides. So again, whether you're a licensor or a licensee, you want to research and be sure this person is going to handle my baby with care, right? Or to be sure this brand is not going to go and do something crazy and then, I stop getting clients because of that, or I stop getting customers because of that. You want to engage an attorney. Y'all already got that covered. I got you. And then, like I said, keep the contract short in the beginning. So there was a group of friends, 3 friends who were going to buy they did buy a franchise. Actually a hookah shop. Very interesting niche. But I think the first agreement was for like 5 years. I was like, no. I'm like, first of all, y'all don't even know if the 3 of y'all gonna be able to work together for 5 years, let alone be in this franchise agreement and paying royalties and all these other things for 5 years. That's a long time. So let's do 2 years. So think about that. Let's keep things short in the beginning. Let's work our way up. That's going to be usually on both sides' best interests. Not necessarily on the licensor's best interest. The licensor typically wants to have a longer agreement so they can count on that money, right? For 5 years, 10 years. But also as a licensor, if someone is not protecting your reputation, you would want to get out of that agreement. So yeah, I really think on both sides it's good to keep it short in the beginning. Okay, now I've been talking a while, but we're going to talk about responsible AI just briefly, because I know AI is all over the place. I know everybody is telling us to use AI in our businesses. I almost downloaded ChatGPT like, I don't know, maybe like 4 months ago. And I was so close, started doing something else, never went back to it. I'm sure I'll revisit it. I'm sure it's people who work for me that use, I know they use AI. Like my business coach, I know she uses AI. And she's been telling me you need to use AI. And I'm like, it's on my list. But I'm sure most of us are using AI or are about to use AI or have somebody working for us who use AI, which is great. What does that mean in terms of our intellectual property? So specifically copyright law. Copyright law protects our written works. So if we put down something, a work of authorship into a tangible medium, is protected by copyright. So our books, our poems, our movie scripts, our music, our drawings, our pictures, these are all protected by copyright law. Copyright law only protects original works of authorship. So the two questions are, can we claim that something AI generated is original? Is it really original if the AI generated? And can we also claim that something AI generated, that we are the author of it? And so in a nutshell, the answer is, it depends, right? A lawyer's favorite answer, but it really comes down to the level of human involvement in the creation. And so this is a topic that's being heavily litigated right now, and it differs from state to state. So I don't have a cookie cutter answer for you, but what I will say is, if you want to increase the likelihood that something will be protected by AI, would be something you create is protected by copyright and you use AI, you want to be very involved in it. So for instance, in this presentation, I had Canva, I typed in like the type of photo I was looking for. I had AI Canva generated for me, and it came up with the picture. I literally typed in 3 words. I don't think that I have a great claim to trying to own the pictures that Canva created. I'm sure it's probably in their terms and agreements somewhere that, you know, our images are our images type of thing. That's why you never create a logo on Canva, because Canva owns it. That's a sidebar. But anyway, I had very little to do with the generation of that image. I just put in 3 words. I didn't pick the colors. I didn't pick, you know, really what the person looked like or anything like that. I just put in like 3 or 4 words. And so I would say I have a very low stake in a copyright claim to the picture generated right now. But if you are putting in very detailed things, say for instance, if you're trying to come up with a new coaching curriculum, I want a coaching curriculum that's six weeks that teaches business owners how to, not business owners, it got to be specific, that teaches accountants how to get 10 clients within the first week and how to generate. I mean, I would say as specific as you can be, in terms of how you describe the program and in terms of the output. You put that into AI and it comes up with the curriculum. I think you have a good chance of owning that, in part because who else can come up with that combination of words? You know what I mean? Now, of course, it's possible, but if nobody else could come up with that, it's a million words out here, right? If nobody else can come up with that combination of words and put it together with that same outcome that you asked for, then I think you have a very good ownership claim to that curriculum. But if you say, hey, I just want a curriculum for business owners that's going to increase their sales, no, that's going to be a million different options. And I'm willing to bet money that 10 other people are asking Chat GPT that same thing at that same moment that you're asking. And so if you want to be able to own these things, be involved. Be very involved in how they are developed. You know, I know that there are functions where you can pick like your audience. I want copy for Black women in Detroit with 2 kids. You know, you can be very detailed, you know, and what your client looks like. So I would just be very involved. If you want to be able to own, you know, the things that are being generated by AI, I would be very involved and I would be very specific. And I will also read the terms and agreements, the terms that you're agreeing to when you use these different things. So like Canva, I'm pretty sure, because you wouldn't own the logo generated by Canva. I'm pretty sure the same thing. This is a new feature with these pictures, but I'm pretty sure it would be the same terms. So I wouldn't use Canva, you know, if I'm generating things like that. But if you're using something else, you know, if you're using Chat GPT and Chat GPT is saying, hey, you know, whatever we generate, that's yours, then, you know, use it, but be involved and describe your things in a way that it would make it almost impossible for someone else to use that exact combination of words and get the exact same result. So that's what I would say. I would say use it, but be involved. That's my final takeaway. And that's it. Thank you for attending. Thank you for rewatching. If you have any questions, definitely let me know. I definitely want to know, what are you licensing? Is it going to be your own product that you are giving a license to, or are you going to license something else? But let me know, and I'll talk to you all soon.